thank you for joining us today. We appreciate you being here for this special presentation about updating your estate plan to meet your personal financial goals. And for those of you who don't know me, I'm Tracy Elliott, the President and CEO of the Anti-Cruelty Society. So I'm excited to welcome, first and foremost, our members of the Rose Faye Thomas Society. Rose Faye Thomas was our founder, as many of you know, and the group that recognizes those who have named us in their estate plan are members automatically of the Rose Faye Thomas Society. If you have named us in your estate plan and have not informed us, just let us know, and we will add your name to that roster. It is published in our annual review, in our annual report, and in other places. Plus, we have events like this, and we will eventually have on-site events as well, just for the Rose Faye Thomas Society. So please let us know that. Also joining us are members of our Humane Heroes organization, which is our leadership circle, giving for individuals who are supporting us with an annual gift of at least $2,400 or more. And if I can get my cursor to move here, there we go. And also members of the Open Door Sustainers Club, those who give us monthly donations at any amount. Some of you have given monthly for more than a decade, and we're very grateful. The Humane Heroes and Open Door Sustainers are really the core of how we have enough money to operate every year, and we really appreciate your loyalty and your dependability. And it helps us to know to do good financial planning, good budgeting, and to be able to meet our standards of best care for animals at all times. I'd also like to thank Sarah Ames, one of our generous volunteers who's with us today, for helping connect us to Quarles and Brady and bringing this webinar together. Thank you so much, Sarah. We appreciate it. And lastly, our friends and partners, some of you who may be joining us for the first time, we welcome you. As I said, we couldn't do any of this without your support. Most of the revenue that we have to fulfill our mission is our gifts from people like you, who love animals and believe in our mission and are willing to invest in us to fulfill our mission. So we appreciate that very much. We have donors all around the country, and people who have been with us for 28 years at least, who have been giving to us annually for decades, and we feel really special about that. We think of our donations here at Anti-Cruelty Society in sort of three buckets. We call it today, tomorrow, and forever. The today donations, like the Sustainers Club and Humane Heroes and anybody who gives us any money on an annual basis, that helps us run this organization day to day to make sure that we are here as an open door for every animal that needs us and all the other things that we do in the community. The tomorrow donors are those who donate to special initiatives, or in some cases, perhaps in the future, hint, a capital campaign where we are going to do some really big things. We do have a funding initiative that is going to be made public fairly soon, and it's incredibly exciting, and it is going to position us tomorrow, meaning in the near future, to really respond to what the community needs from us and what the animals in the community need for us. So those are our tomorrow donations, and then there are our forever donations, and that's what we're here about today. Those of you who have remembered us in your estate plan, you are making sure we're here forever. We receive bequests and estate gifts every year from people who have thought about us years ago and put us in their will or in their trusts, and we receive those dollars, and those really help us to do both operate the organization on an annual basis, but also to be financially secure for the future, to make sure that we're here 123 years from now, so whoever is running the organization then can talk about the 123rd anniversary or the 125th anniversary that's coming up, except we'll be 225 at that time. But it is these kinds of gifts that ensure that we are here forever. So we thank you so much for remembering us in your estate plan. And again, if you haven't, we'd be happy to talk to you about how to do that. And you're going to get some ideas today from our great speaker as well. Today's topic is exactly about that. It's August is National Make a Will Month. And so it's a perfect time to plan for your future and make your mark on all that you care about. Whether you already have a will or are in the process of creating a will, or just looking for more information, we hope this webinar is a resource for you to use and seek answers to your question. You can also learn more about legacy giving and our Rose Faye Thomas Society on our website at anticruelty.org/planned-giving. Or you can talk to any members of the staff, myself, Rhett, Lauren, and whoever else is on the call. Just let us know. We'd be happy to have that conversation with you. Before we begin, I'd like to tell you a little bit about where we are at the organization right now and how you have helped us adapt to very, very turbulent times. Even after whatever part of the COVID drama we are in, are we at the end of it or at the beginning of the end, or are we post-COVID? It is still a turbulent environment. Things are not the way they were before. And so we have to be very nimble, and we have been so. And after I tell you about that, we're going to then welcome our guest speaker, Kirk Hoopengarner from the Chicago office of Charles and Brady, who brings a wealth of talent and expertise to you today about estate planning. And one quick housekeeping note, we are recording this session for those who are unable to join us this afternoon, and all of our guests have been muted so we aren't competing against the background and other noises. And when I stop talking, I'll mute myself as well, because there are, if you can't hear them, there are dogs barking in the background. That's a surprise, isn't it? There's only about 150 dogs here on site. We get to hear them all day. So we encourage you, by the way, if you have any questions, to put them in the chat, and we will attempt to answer every question that we can by the end of this seminar. So a few things that are happening around here real quickly. This Saturday, August 27th, we will host Clear the Shelters, a traditional an event that happens every year, and it happens at a really good time because this is the time when we tend to have a surge of animals, particularly dogs, into ACS. To find loving homes for all of our adoptable animals, we are waiving all adoption fees on Saturday, August 27th. If you or someone you know is looking for your next best friend, visit the Anti-Cruelty Society at both our River North location at Grand LaSalle, or also one of our PetSmart locations this Saturday. The event is sponsored by Steve Parenti, one of our most loyal friends and donors, in loving memory of Albert and Marcel Russell Parenti, his parents, and his fur friends Cookie and Peanut. And a special thanks to Hill's Pet Nutrition for their support of this event as well. The day after Clear the Shelters, August the 28th, ACS is participating in the Museum of Illusions Dog Days of Summer event. That sounds so fascinating. Enjoy a thrilling museum experience with your fur friend from 9 to 11. There'll be fun photo ops, treats, samples, and giveaways, plus all proceeds from the event will benefit ACS and our mission to help homeless animals in Chicago. Soon we will share news about our strategic initiatives for the future. Our board and staff, our funders, our donors, our volunteers, and community leaders and shelter experts have been working for over 3 years to determine what the vision of this organization is for the future, what our vision is for the future, and then how to put that into operation. And we are very close to announcing the very first phase of that really exciting plan. I can tell you that the future of this organization is going to be exciting, it's going to be fulfilling, and it's going to reflect the passion, but also the innovation that Rose Faye Thomas brought to the founding of this organization. And so we're excited to tell you more about that in the very, very near future. And that will give you an opportunity to help us tomorrow, as well as today and forever. So without talking too much more, I'd like to introduce our guest speaker. Kirk Hoopengarner has been a partner in the Chicago office of the law firm of Quarles and Brady since 2011. For over 37 years, he has concentrated his law practice on all facets of wealth planning, trust and estate administration, and philanthropy. He's a frequent speaker and author, especially on charitable planning topics, and has been very active in various leadership roles in Chicago region's philanthropic sector, including having served as board chair of McGall YMCA of Evanston, board chair of the Evanston Community Foundation, president of the Corporate Responsibility Group of Greater Chicago, president of the Evanston Township High School Foundation, and is a director of the Davie Foundation. That is a very impressive list of community activities. He's on the editorial board of the Plan Giving Today and is a frequent contributor to that online publication. Kirk is currently serving on professional advisory committees for the Ann and Robert Lurie Children's Hospital Foundation, the Lincoln Park Zoo, and the American Endowment Foundation. Kirk is an adjunct professor at Northwest Pritzker School of Law, LLM tax program, where he is co-teaching a course on tax-exempt organizations. Kirk, we are very grateful that you have agreed to spend some time with us today, and I pass the program on to you and look forward to hearing what you have to say.
Thanks so much. Thanks so much, Tracy. And it is an honor to be speaking to you today and the sponsoring organization being such a wonderful organization like Anti-Cruelty Society and its mission. Today, I just want to give you really an oversight of different things that people are thinking about. Estate planning has really gotten on the forefront of a lot of people's minds in the last couple of years. The pandemic really forced a lot of people to start thinking about putting their lives in order. And we're not just talking about what happens at their death. We're talking about putting things in order during their lifetime. So if we could pull up the slides and go to the first slide on healthcare. And if we go next slide. So the first thing I want to talk about is healthcare. It's not a financial issue, but it's certainly an important issue. And the healthcare issues have become quite important in people's lives. And in probably the last 20 to 30 years, there have been various initiatives really joined in partnership and collaboration with the legal industry and the legal sector and the medical sector to provide people a means of doing advanced directives. And what do I mean by that? These are directives that say, if I become incapacitated, here's who I want to be in charge of my healthcare, to make decisions for me. And those healthcare initiatives are usually forms that are provided by the various state legislatures. And they're forms that not only designate people with this authority, but also often give them access to medical information and also talk about life support decisions, very significant and important decisions that need to be made potentially in the future. So we always encourage people as part of their basic estate plan to have some type of an advanced directive. If you don't do anything, some states even have healthcare surrogate laws that have some backup automatic default. And most of the time, people don't necessarily want that. There are certain alternatives to the state forms. Some of people in the audience may have signed 5 Wishes form, which is a form that provides a lot of detail about not only medical decisions, religious decisions, funeral and burial arrangements. There are things that you can put in place for the disposition of your body and other things. You may have heard of this concept called a living will, kind of an unfortunate term that's been used for years, where you tell the physicians in the medical world that if you're in a certain really bad way, an irreversible coma, you're having a situation healthcare wise, that you're authorizing the termination of life support. This has really gotten front and center in the news a lot in recent years, where people have been kept alive, perhaps not in the best state. They're not communicative, they're not participating. And most people, at least philosophically, say, I don't want to be stuck on a tube. Next slide. So let's go to the next in long-term care and related in the next slide. This is another healthcare issue. And we are increasingly having challenges in our society about care. And sometimes the real concern of a lot of people is, how am I going to pay for this? There are long-term care insurance policies that are continuously being offered by the insurance industry. And there are various forms of relief and aid that they provide you. It's important to carefully review those if you're going to consider them, especially be leery of very low-cost policies that may be a bait and switch, where you get a low-cost policy and then suddenly have the premiums raised substantially in the future. Determine whether you want home care and make sure that it's provided. For a lot of people, that's important. And the deductibility the deductibility part of this policy is often something to look for. Is it 90 days? Is it 6 months? What are you going to cover? The one thing that I really encourage people to do, having experienced this both with my clients and also personally, is have a plan. Have a plan for what happens when you do break that hip, when you're hospitalized, or worse, you have a stroke and you're seriously incapacitated. Who's going to take care of you when you come home? What type of services are going to be provided? Who's going to be in charge of arranging for this care? What we're seeing more and more is the challenges that people are facing is their children and their loved ones are all over the country, not necessarily living in the same locality that they're living in. And this becomes a real challenge logistically. And so I always tell people ahead of time, talk about, especially in the rural areas, what kind of agencies are out there? What kind of services are even available? Who can you contact? Start putting together lists, start doing your homework, having a plan. And the other thing is having a plan for if mom or dad pass away, if mom or dad fall down and they are incapacitated, who are the families going to come in and take care of them, make sure things are in order? If we could go to the next slide. So turning to financial management, the next slide, let's talk about different ways of providing for financial management. And again, there isn't a theme here that I'm talking about as far as life planning, and that is dealing with incapacity. Most states, Illinois included, have a property power of attorney form that you can execute. You can say who you want to basically make decisions for you. You can have it as a springing power in effect that it's only comes into effect, and the power is only given if there's a determination by your physician that you're incapacitated. Most forms need notarization, they need witnesses, they are forms provided by the states, and you need to abide by them and you need to follow them. If you take a form, even though most states do allow you to vary from these forms, it's best to try to keep it within these forms because that's what the banks and other financial institutions are looking for. The other thing is keeping a running memo. I kind of call it the note to the babysitter, but the other is keeping a running memo of key information about your financial management. Where do you pay your bills? Are there security codes for getting access online to your accounts? Who are the key players? Your accountant, how do you pay income taxes? How do you file tax returns? Where do you keep your papers? Something that would be a running memo. And I say, if you get hit by a truck, you're incapacitated, and some family member or friend is now stepping up, or a financial institution that you've named as your successor trustee and agent is now stepping in to manage things. You want to make it easy for them to basically find all the moving parts of your life, of your financial life, so that they can carry on the management of your affairs. One of the big things that should not come as a surprise to the audience today is digitalization of assets and online payments and codes. I've had more than one situation of someone passing on and the family calling me up and saying, we can't get into Joe's accounts. We don't have his codes. We don't know where they are. We don't really even know how to figure this out. I had one situation where the mom and dad had 10 different bank accounts. Children took over when both of them became incapacitated and took over, and they called me with great pride one day. Oh, we've consolidated all the accounts into one. We're so happy. It's now going to be a lot easier. I paused and I said, well, okay, did you keep the account that pays the bills? And there was silence, and all of a sudden they realized they had closed the main account that paid all their bills. and they were getting dinged in late notices because they were getting these automatic bill payments going through an account that no longer existed. So it's good to have communication, a plan, and a written out roadmap for basically how to handle things. If we go to the next slide. Inventory of your assets, just updating them once in a while. Confirm how things are titled. People so often will do things many years ago in the titling of cars, the titling of houses, the titling of vacation homes, and they kind of put it on the shelf and it collects dust and they never look at it again. Periodically make sure that still conforms with what you want and how things are titled. If your beneficiary designations are out there for retirement accounts or for life insurance, check on them periodically, update them. I've had situations where people have passed and they had a beneficiary designation to a former spouse that was done 25 years ago. They never updated it. Needless to say, that caused a little bit consternation, some issues with how to deal with the beneficiary designation. And budgeting and basically spelling out how you are managing your affairs, again, for roadmap for someone who's coming in and trying to make sure that the bills are paid timely and properly and from various accounts. If we could go on to the next slide. One of the things that comes up quite often in the ownership of property is how is joint ownership. And sometimes there's some confusion there. You may have seen this acronym, JTWROS, Joint Tenants with Right of Survivorship. And that is quite a common acronym that's used to designate when you're jointly owned and when one of you dies, the survivor becomes the sole owner. That it's important to realize that because sometimes people will do a joint ownership with one of many children and they do it for convenience. They want it like a joint account. They want that child to be able to have access to it. But they've got to understand that when they die, that child becomes sole owner. And if they expect that account to be distributed among all the children equally, that's not legally what would happen unless there's the child who's the surviving owner says, yes, I'm comfortable with just dividing this among my siblings, or there's some proof or evidence that it was only created for convenience, but not intended to be a testamentary substitute to leave that account to just that one child. Tenancy by the entirety comes up quite a bit. This is a form of ownership in the state of Illinois applying to your principal residence for husband and wife. The intention being it was created many years ago as a way to protect what's called the innocent spouse. If one spouse is sued, a judgment is entered against them, the judgment creditor does not get the right to force a sale of that home to satisfy that judgment. So it does provide some protections if one spouse ends up with a liability. Oftentimes it's a form of ownership by when one spouse is in a profession that is highly litigious and they want to protect the equity of their home. It feels a lot like joint tenancy. When one spouse dies, the other spouse becomes the owner. It's important though, if you're going to use this type of ownership, and in some states you can use it for other than to just not only the homestead, but other assets, it's important that you use this terminology. So you'll probably, a lot of you who are in this audience that are married have your homes that says, not as tenants in common, not as joint tenants, but as tenants by the entirety. And that's important language to get that special protection. Next slide. The other thing that's become very popular, probably, I want to say the last 10 years, is another probate substitute. It's transfer on death, TOD, payable on death, POD, designations. A lot of the investment firms have offered this as a way to avoid having to go through a trust, which I'm going to talk about in a minute, or go through joint ownership, which has some issues there as far as the potential risk of having a jointly owned asset with someone else and they become sued and suddenly this asset is subject to their creditors. The transfer on death is something literally is transfer on death. And it's a designation that you can amend or revoke later on. So it is testamentary in nature, but it's a way to ensure ownership, it transfers fairly smoothly. And the surviving beneficiary can file a form, a death certificate, and get access to the assets or the account. It's important, however, and sometimes I've had situations where people had a lot of these transfer on death, payable on death designations. They died and it necessarily wasn't consistent with their overall estate plan. And there were some beneficiaries receiving a lot more than what the person intended. So you want to make sure that if you're going to do that type of designation, you keep track of it and it is consistent with your overall estate plan. If we can go on the next slide. The one topic that I would imagine people in this call have dealt with, and is a very popular tool in the trust and estate planning world, is the revocable living trust. It's a tool that's primarily used to avoid probate court as far as the transfer of assets at death. It's especially helpful if you have assets in other states, a vacation home in Wisconsin, for example, where you can have things titled in the trust. It feels like the asset of the grantor who creates the trust. In fact, the IRS ignores it while you're living. They don't even want you to do a separate tax number or separate tax reporting. They have you use your social security number as the number for the trust. You have the right to amend it, revoke it. It's totally within your control. But at your death, you provide a roadmap, which you can amend, for how this is going to be disposed of it when you pass. So it serves as a will substitute. You also can provide successor trustee designation, which is almost like naming your executor, your personal representative of your estate, to basically handle things. It is also a tool that can be used for disability if you become disabled. Most these trusts have provisions that say either if there's a physician that makes a determination or a loved one makes a determination that you're incapacitated, a person or an institution will step in and take over the management of this trust. It's really a very helpful tool, and there's a lot of people that have these living trusts. But I will say there's a lot of people that have trusts that are what we call unfunded. They do the will that pours into the trust. It says, if I haven't gotten around to getting anything into the trust, pour it into the trust. They do the trust, they put the documents, and they think they're all done. But they haven't placed anything in the trust. They haven't deeded the home into the trust. They haven't put their investment accounts in the name of the trust. They haven't named the trust as the beneficiary of their life insurance. So this trust is unfunded. It just is sitting out there. And if that's the case, it really doesn't fulfill the need and the purpose of trying to avoid probate. So there is a two-step. You sign the trust, but then you engage in transferring assets and titling assets in the name of the trust. Next slide. Now let's talk about the probate process. Next slide. Probate, I'm sure you've all read the books and the stories of the horrors of probate. And for many years, there was a big impetus to avoid probate. Probate court's terrible. It's complicated. It's extensive. It's costly. It really isn't. It doesn't have to be. It can be a fairly straightforward process. Granted, in the COVID times, it's been a little bit more of a challenge to get before the judges and do these Zoom hearings and other things. But for the most part, even that's been fairly straightforward. And if you don't have a controversy, if you don't have any kind of issues with the family or otherwise, you don't have major creditor issues, it can be literally 2 court appearances to open and close. And in many respects, the idea of avoiding probate may be overrated for people. Nonetheless, there are people who don't want publicity. We've had certain major personalities in the city of Chicago die, and people said, well, what did his will say? And it turns out that the will said, I hereby transfer everything to my trust. And the trust is the guts of his estate plan, and that's kept private. And so nobody knows exactly what he has done with his estate. So there are some privacy benefits. Also, if you don't probate, you don't have to state to the world your net worth, which is at least the basic acknowledgement in your probate forms. And it does make things easier for the transferring of assets at your passing to use the trust or the other mechanisms, devices I've talked about to avoid the need for probate. But I will say that probate process, generally speaking, is not as complicated. The other reason why some people want to avoid probate is that they feel it gives a bit easier forum for somebody to come and contest their will and contest their documents than through the trust. And that may be, but if things really get ugly, it's going to be contested. The estate plan will be contested probably in any event. But there is definitely, we always encourage people to avoid probate. We certainly want to avoid the probate process in the event of disability. That's through what's usually called a conservatorship or guardianship. And that's very time consuming, it's expensive, it's emotional. The person has to be served, there has to be a doctor report, there has to be an evaluation of incapacity. It's a difficult court procedure that you really want to avoid. And the best way to avoid them is using these tools I've talked about, powers of attorney, trust, as mechanisms to manage things for you if you become incapacitated. Next slide. Well, we have to talk about, there's two things certain in life, death and taxes, right? So we have to talk about estate taxes. And we've been in a really strange time in my practice. I started practicing in 1984. And boy, have I seen a lot of changes over the years, but nothing as remarkable as what's happened in recent years, where the federal estate tax exemption was basically doubled. And the other thing that was given was this concept of portability, that if one person dies of a married couple and they haven't used this exemption through all these tools that I won't really go into today because they're really not as relevant as they used to be, at the surviving spouse's death, they can use the exemptions of each of them and transfer wealth to their non-charitable beneficiaries, children, family, friends. And the exclusion is remarkably high. It's now 12.06, doubled. So we're talking $24 million, which means most of the American public has not had to worry about the estate tax. Next slide. If we go to the next slide. So the portability was a relatively recent concept. And if those of you who have done planning over the years probably remember the good old AB trust, we were trying to have husband and wife each have certain assets in his or her names. And we went through this process, and the federal government just totally changed that by saying, you don't have to go through all that. If you don't use your exemption when the first of you dies, the survivor can use that later. So it was a pretty substantial change in our law. If we go on to the next slide, but this exclusion, this big exclusion is now scheduled to sunset in 2025. Last year, some of you may have heard of all the rumors and proposals that were made in September of last year to accelerate that reduction to this year. It didn't happen. It was dropped from the final bill. And basically, I don't think there's any chance of that happening, especially if we have a shift politically in Congress this fall and the Republicans gain control of both the House and the Senate. We will likely not see that. And we may even see something where that favorable exclusion sunset changes. We just don't know. The one thing that Congress has done for us, some people say it's the Employment of Estate Planning Attorneys Acts. They constantly are changing things. They're constantly switching things. It's really hard to do planning and figure out where their heads are at. And this is a good example. Next slide. So we're just now been in the process of trying to figure out, for clients who are kind of in that sweet spot of 10 to 20 million, how do you deal with this possibility of this exclusion going away? And there's been a lot of planning to do to try to figure out how to take advantage, because one thing the IRS has made it very clear to us is it's a use it or lose it proposition. If you have a $20 million estate and you don't use the $20 million that's currently available to you, and it goes down to 12 million as a couple, you're stuck. You lost that $8 million. You can't recover it later on. And so there has been planning, but I think, quite frankly, what I'm seeing and other people in my sector are seeing is a lot of wait and see. Let's see what happens politically this fall. Let's see what happens in the first quarter of the next Congress before we do anything. We don't have to rush necessarily to do any planning and any gifting. With that said, most think that this exemption is going to decrease. And if you have a really substantial wealth, there's no time like the present to do planning and gifting programs. Next slide. So we are still engaged in helping clients give away assets at the most tax efficient means possible. depending, and there are some fairly straightforward things. Everybody can give away $16,000 a year per individual. That's an annual exclusion that's been granted for years. It's ratcheted up periodically. It's now at 16. You can pay tuition of your grandparents, for example, can pay tuition directly of their grandchildren. That's not treated as using any gift tax exemption. Medical expenses and health insurance can be paid. And there are certain tools that have been in our toolbox forever, like grant to retain annuity trusts, that allow us to make gifts and get growth out. Some of these tools have kind of lost some of their luster with the way the market's been this year, and with predictions that perhaps we're at a time where the market will be fairly level, if not down. Recession comes into the picture. And because some of these techniques are trying to get the growth out of your estate. Well, if your estate's not going to grow that much, it's probably not as interesting to engage in these techniques. The next slide. You may be in a state where you have to worry about estate taxes, and Illinois has an estate tax, and its threshold is $4 million. They don't have portability, and therefore, if someone has out there $5-6 million and they have it all owned in joint with husband and wife, there is an issue there that when the survivor of them dies, there will be an estate tax at the Illinois level. So some of the planning that we did, the paradigm planning we did for years, may come into play here, where we're trying to put some assets in each spouse's name and trying to take advantage of their Illinois exemptions, or at least part of it, to avoid Illinois estate tax when the survivor dies. Next slide. Let's shift over to individual retirement accounts. And in that area, we have had a major shift in planning at death by the Secure Act. It dramatically changed the distribution options we had from qualified retirement accounts and IRAs. In the past, before that Secure Act was enacted, you could set up an inherited IRA for a child, even a grandchild, and you could have the minimum distributions required of that after your passing to your child or grandchild spread out over their life expectancy. It could be it was called the stretch IRA. And it's the beauty, and the reason why you're doing that is every dollar you pull out of the IRA, you have to pay taxes. And so the longer you can defer, usually the better off you are, because you're growing it, it's investing, it's earning, and it's good, and it's tax advantageous. What they did with the Secure Act is they said, for inherited IRAs, you got to pay it out in 10 years. And one of the things that's caused some consternation is, what do they mean? Do they mean by the 10th year, which is what we thought originally? Or do they mean you have to start sprinkling it out in year 1 through 10? That is still the safe way, is to start taking out minimum distributions in 1 through 10. And that seems to be the safe approach to this. But it definitely has caused people to view the way they leave their IRAs to their children and grandchildren and family and individual beneficiaries a little bit differently, if they were counting on allowing them to be able to draw it out over time. Next slide. Individual retirement accounts had a favorable tax treatment that was available to you that has been around, and for a while Congress couldn't make up its mind whether they wanted to make it permanent or not, and they changed their minds quite frequently, but now it's permanent. It's called the charitable IRA rollover. If you're 70 and a half or older, you can direct distributions directly from your IRA to your favorite charities, public charities. They can't go to a donor advised fund. They can't go to your private foundation, but public charities. And that is treated as not coming to you. So you don't have to report that as income on your return and then take the deduction. And for people who don't itemize their deductions, this can be a very tax efficient way to make charitable contributions. They're taking what would otherwise be taxable income, and they're not having to report that on their return, and they're sweeping it to the charities. It's important, if you're going to do this, that you're doing it toward, at least start thinking about doing it in October. Don't wait till December to think about doing this, because most of the financial institutions starting like mid-December will say, don't even bother trying to do these things by the end of the year. We can't process it. So it's important to start doing it sooner than later if you want to do it. to make a distribution and you work with your charity, it has to go directly to the charity. The charity will provide you a receipt. They have to announce to the world that they got this money from your IRA without giving you any goods and services. And then basically you're going to get an IRA 1099-R that will show that you had charitable contribution that went out to your charity during a year. Next slide. They really, I think the one thing that I also tell people to do and consider with IRAs is the beneficiary designations. If someone comes to me and they're considering leaving $25,000 to the Anti-Cruelty Society, I would say that's awesome. Why don't you give them 50? No, that was for Tracy's benefit. But anyway, I would say that's great. And I look at their assets. And let's say they're not even in a taxable situation for estate tax purposes. Let's say they have a net worth of about 2 million. I would say best asset to use is the IRA, because that will be subject to income tax no matter what when you die. And therefore you're saving the income tax by having that go to the charity. So that is something that I always encourage people in their portfolio of assets to consider as a good tool for giving to charity. Next slide. Well, I had to include a slide, of course, about providing for pets for this audience, because I know that this audience is very concerned about animal welfare, and I would suspect many of you, if not all of you, have animals in your life that you care for and care much about. And therefore, if that's the case, I encourage people to come up with a plan for what would happen to you to make sure your loved animal is cared for. And there is a pet trust statute in the state of Illinois, many states have this, where they provide general guidelines where you can set aside money for the care of your pet. And you can also, you need to provide who's in charge of that. And basically you need to also provide what happens to it when your pet passes. And usually it's the normal thing I see people do is having it go to a charity such as Anti-Cruelty Society that is devoted to animal welfare. It's consistent with the overall theme. But that's a way that you cover, you make sure that, and you kind of come up with a dollar amount that you think will be safely enough to cover the needs of your pet. And the key point is coming up with a trustee that will manage that money and make sure that it's used for the care of your pet and that it's eventually distributed to your favorite charity or to other individuals. You can have it go to other individuals.
Kirk, this is Tracy. We want to try to wrap up in about 5 minutes if possible to allow some questions.
Okay, next slide.
Thank you.
So go on to charitable giving. So there's a lot of charitable giving techniques that I would just stress allow you to give but retain income interest. One of the examples of that is a charitable gift annuity. You give money to the charity, and Anti-Cruelty Society offers this for donors, and then they pay back an annuity. So they pay you back an annuity, often for life. Sometimes you can do a deferred until you retire, for example. Sometimes you can do it for a term of years. So you're getting back an annuity. They set the annuity rate usually based on the American Council of Annuities. They set rates with the assumption and the hope that 50% of what you've given them will end up going to the charity. Why is that important to point out? It means that you're going to get a lower annuity payout than you would with a commercial entity and a commercial annuity, but you are giving to the charity. So it's a win-win. You're pulling back income and you're giving to the charity. The charitable remainder trust is a more complex tool that's used in that regard for a trust that you take back an annuity and you give a remainder. Charitable lead, you give a lead annuity trust and eventually have the balance go to family and friends at the term. And then sometimes you can give irrevocable gifts of remainder interest in farms and vacation homes to the charity that you set up right now. Next slide. Donor advised funds, I have to just actually mention them before closing here, are very hot right now, very big in the philanthropic sector. You give money to a sponsoring organization, usually it's a Fidelity or a financial institution, a community trust, or like a Jewish Federation or Catholic Charities. You give money to them, They are now in control. They control this contribution. It can be non-cash gifts too. And then you have the right to request and advise over distributions from this fund. So you get an immediate deduction, but it's almost like a charitable checking account that you can then give out over time. Next slide. The one thing that I think that is important is that when you're setting these things up is that you make sure that you have a succession plan. When you die, who's going to be the successor advisors, or you can request that it be distributed to your favorite charity. Next slide. One of the things that I stress is if you're reluctant because you just don't know how long you're going to live, you're worried about healthcare, you're worried about the market, you're worried about expenses in your life, and you're just not sure, is you can make gifts at death. And you can put restrictions on how the money is to be used. You can set up funds. It can be a wonderful legacy for your family. It doesn't have to be a sacrifice to your family financially. It can be a portion of your estate. And it doesn't necessarily have to be complicated. So I always encourage people to consider planned gifts. Next slide. So one example is the Rose Fay Thomas Society that Tracy alluded to at the start of today's session. And that is, it's a way that you can provide a legacy, a long-term sustainable. It helps if you've been very generous in your lifetime donations to the charity. Just imagine what it will be like when you die and that's not continued. It definitely has an effect on the charity. But the way you can continue that generosity after your death is to set up a fund or give money. And you can also provide a way that you're telling them, I believe in this organization, the sustainability of its mission. And then you become a part of a society that can provide additional benefits to you, to tours of the center, various ways to talk with personnel about the mission, various ways to be involved in what's going on with the organization. So it can be a wonderful way to sustain the mission of the charity, to join a legacy society of your favorite charity. Next slide. I think that I conclude by just saying, plan, plan, plan. You know, the quotes I have here really, say what I believe in substantially. That's why we call it estate planning. You plan for the future. We all are going to die someday, and plan for that point. It's a strong likelihood, sad to say, that we become disabled someday, incapacitated. Plan for it. Don't wait for the last minute. Don't procrastinate. Get things in place. And I always tell people that the sooner you do it, the better. The worst estate plans, the most troublesome estate plans I've done are ones where people are literally dying in the hospital. And we're talking through that. You don't want to wait there. You want to provide a roadmap for your family and friends and make things easier for them. So with that, I'll turn it over to questions.
Thank you so much, Kirk. I used to be in the trust and estate and investment business with a bank, and that's probably one of the clearest and most easily understandable presentations of this type that I've ever heard. So thank you so much for that. Great information. We do not have any questions in the chat that I see. However, are there? Oh, wait a minute. Yes, we do. Will the slides be made available? Kirk, with your permission, can we make slides available to? Okay, great. Another question is, with market volatility and concerns over being able to meet living expenses, how do people consider charitable giving capacity?
That's a great question. So a lot of financial institutions offer various Monte Carlo and other simulations to say, okay, if you gave $50,000 today, will you run out of money? And using worst case scenarios going forward. And it gives a peace of mind to people. So if I would encourage you to talk with your trust officers, your investment people, to see if, and your accountants, to see if they have that possibility. But in some respects, I hate to say this when I'm doing a presentation for a charity, but you want to be comfortable.
Yes,
I don't think the Anti-Cruelty Society or any good charity would want you to make a gift that you're not comfortable, and that makes you feel a little nervous that you're going to run out of money. So, but I think in some respects, you can do a little bit of your own forecasting and budgeting. I think one of the challenges a lot of us face is we don't do enough budgeting. We don't do enough financial planning. It's a really interesting exercise because I have some clients that will come to me and say, I finally sat down and I kind of went through my expenditures last year, including my charity. And frankly, I think I got to scale back on everything, my trips, because otherwise I'm going to run out of money. But so I think part of it is doing that. But I'm very cognizant of the fact that people are concerned about healthcare costs and especially, but they want to be charitable. But then that comes back to, especially if you don't have any people depending on you when you pass, that comes back to saying, listen, if you're uncomfortable, if you're an 80-year-old and you're sitting there and your family tree says you could live to be 100, then you don't have to, you can make a very nice planned gift that helps sustain the mission of your charity without causing you to have sleepless nights wondering if you're going to run out of money.
Right. Thank you. That's great. Great answer. Karen asked, at this point, what do most people leave for the care of a pet who is young? For instance, a 4-year-old and a 2-year-old cat.
Boy, you probably have more expertise on this, you all, than I do on what the answer to that is. But I think, I hate to ask this of you, Tracy, and the staff at Anti-Cruelty Society, but do I dare suggest that if you're kind of trying to get a gut feeling of cost of taking care of a 3-year-old pet that could live another 15 years, hopefully, maybe, the Anti-Cruelty Society has a fairly good sense of what that is. Obviously, part of it depends on the vet, where your care, if this animal has certain tendencies to have certain substantial health issues down the line, which I know certain animal breeds do. So I don't have an easy answer to that. Usually my clients err on the side of the high side. They want to have a cushion. They don't want, and so they may put a little bit more, especially if the end, whatever's left over, is going to their favorite charity anyway.
Right. Yes, it is hard to know for sure. I mean, everybody knows what they spend on their pet annually, or some of us don't pay attention to it because if we knew, we would be frightened by it. But and then you might use that as kind of your base as to how many years you think the animal might live, and then obviously add additional for anything that might come up of a medical nature. We're working on some additional options for that here, and as soon as we have that work done, we'll reach out to all of you and let you know. There's really only time for one more question, so I'm going to, and this is a really good one. It's from Marie. Is irrevocable trust recommended over a will if I have a beneficiary 401k but need to distribute in the next 10 years, but will not be 70 in the 10 years? Can I have a required distribution given to anti-cruelty?
Okay.
I think that's two questions.
Yeah. So, yeah, and I think that the first question, just to make it clear, I typically talk about revocable, not irrevocable, and I always have to pronounce that carefully in conversations because it causes confusion. So, Marie, your first question we're talking about revocable trust versus a will. And I would tell you that if it's important to you to avoid probate court at your death, recognizing what I talked about, that it's not necessarily the most expensive proposition for most people. It really, Brett just provided us some pet cost examples and thoughts. So thanks, Brett. I would say a revocable trust may not be absolutely necessary for you. If you are relatively young, you may think, well, I'll have a revocable trust and I could use it later. This is something, it's a bucket that can be filled later through your own transfer of assets or through your power of attorney usually says that. So I guess the long answer to a short question is, I don't think it's absolutely necessary, and I don't think a will versus a revocable trust is something that is slam dunk. I will tell you, in our estate planning community, and since Tracy just said that he had a trust and financial investment background, he would concur. We definitely promote use of revocable trust as the primary estate planning transfer tool, but it's not I wouldn't say it's absolute. And I definitely have sometimes where young couples come to me and they say, I just want to do a simple will, Kirk. I don't want very complicated. I just want to make sure I name guardians for my children. And that's all they really want to focus on. And that's fine. And they can do wills. The second part, I want to make sure, I hope I haven't misled everybody about the Secure Act and the 10 years. That doesn't apply while you're living. That only applies when you pass to the people that inherit your IRA. And so basically the non-spousal, there's spousal exceptions too, without getting too much in the weeds. So what you were talking about is if you're under 70 and a half, you don't have to start taking money out in the next 10 years. That's not telling you to do anything. The rules are, and now it's 72, just to throw another wrinkle, is that when you're 72, you have to, while you're living, to start taking money out of your IRA. And it's based on your life expectancy and a formula. When you die is when the Secure Act kicks in with this 10 years. If you want to start, if you're now at that 70 and a half, actually 70 and a half, and you want to start taking money out of the IRA and give it to the charity, that's when you can do that. You can give it to the charity and not pay tax on that withdrawal. And frankly, if you don't think you're going to need that IRA money to live on and to sustain your living expenses, it's a great giving tool for you. Especially if you say, oh, Kirk, I'm thinking of giving $100,000 anyway to the Anti-Cruelty Society. When I die, I'm 75 years old. And I say, well, how about give 10 a year now from your IRA and do a rollover, do an advance. Now, one thing I want to say on that point is that I will tell people if they're going to do that, but they all totaled want to give 100, that they have a formula, something that says in their estate plan, I give 100 to the Anti-Cruelty Society, less what I've given to them from my IRA in the last 5 years or something like that, so that they're not overdoing it. I'm sorry, Travis, I'm sure you would like to have 100 plus, but anyway, that's what I tell people. But just so, Marie, you're clear, I really hope I haven't misled people to think the Secure Act applies while you're living. It doesn't.
Right. Thank you. I think that's clear now. Thank you so much, Kirk. We're out of time for questions. I will say real quickly that as we approach the fall, if you are over 70 and a half and would like to make a charitable contribution from your IRA, contact us and we can help you with that. Those are becoming much more frequent and they're win-win propositions. You don't have to pay taxes and we get to save more animals. So let us know if we can help you with that or any other such questions. Yes, exactly. There, talk to Rhett, talk to Lauren, call me. We're happy to help you with that, obviously. So thank you so much, Kirk, for your generosity and sharing your time and expertise. I know this is a complicated issue for many, but I learned some things today too that have changed because it was a long time ago when I was in this business. In a few days, we'll be sending a recording of this webinar out and also a survey. We very much want to hear your feedback as to whether this was helpful. And also it'll help us, you'll have an opportunity to tell us topics you'd like to hear in the future about our operations, about our programs, about our services, or any other topics that we can be helpful with. We have a brilliant group of people on staff here who can share lots of different kinds of expertise with you. So, and we really enjoy providing this service. So next month is our big fundraiser, Pour Your Heart Out, which will be held on September 22nd at Joe's on Weed Street. It's a delectable event featuring 15 breweries, distilleries, and wineries. So I would recommend you take an Uber, please. And go to Anti-Cruelty. I'm going to be, because actually I can walk there from where I live, but anticruelty.org/pour, P-O-U-R, and get your tickets or donate to the event today. It's going to be a lot of fun. And we might even have some animals there for you to play with. So thank you everybody for your time. Have a wonderful afternoon and we will see you again soon. Bye-bye.
Bye.